We are enthusiastic about authoring Assembly Bill 1710, the Consumer Data Breach Protection Act. Before discussing some of the elements of the bill, I want to point out a few rather, I think, staggering facts. Between November 27th and December 15th of 2013, hackers were able to get access to Target's point-of-sale system, which exposed 110 million United States customers to credit and debit card fraud. In addition, on another poster, we show that since July 18th, 2013, Privacy Rights Clearinghouse has identified over 300 United States data breaches in which consumers' personal information was compromised. Out of more than 450 data breaches investigated, the United States was the top victim location, with 73% of all victims located here in the United States. And it took an average of 210 days for businesses to detect a breach. Only 24% of victim organizations detected the intrusion themselves. Most were informed by law enforcement officers or another regulatory body. AB 1710 stems from the joint oversight hearing held by the Assembly Banking and Finance and the Assembly Judiciary Committees in response to these mega data breaches that took place recently at Target and Neiman Marcus. But this has become a pattern which is all too familiar and growingly more disturbing. AB 1710 provides much-needed protections and a common-sense approach to ensure consumers' personal information is protected, and in the event that information is compromised, businesses will respond timely and appropriately. Consumers need to have the necessary tools to first act to alleviate any damage, whether it is to close a credit card account or call a credit reporting agency, and second, to have the ability to make an informed decision as to whether they wish to further conduct business with the entity that's been responsible for the compromise of the data. Now, under current law, those who own, I want to stress own, consumers' data are required to notify the consumer, not those who maintain the data, where most likely a data breach will occur. For example, Target was not required to notify the public of the breach of its data. It is upon the financial institutions, typically, that the burden falls to notify consumers of a data breach or compromise. And in most cases, because of the way current law is structured, consumers will never know where the breach occurred. A consumer, we think, has the right to know where their information has been stolen from, as well as have a choice as to whether or not to continue to transact business with the source of the compromised data or the breach. So, specifically, AB 1710 would enhance existing law by first, implementing consumer data storage protections, second, requiring businesses to notify consumers of a data breach within 15 days, third, prohibiting the selling of a consumer's social security number, fourth, requiring businesses to reimburse costs associated with a data breach, and fifth, requiring businesses to provide affected consumers with appropriate means of credit monitoring for no less than 24 months. The rising number of data breaches online and at brick-and-mortar retailers is, as I said earlier, disturbing, but more than that, it's actually frightening to many, if not all of us. We know that those who are engaged in the exercise of trying to steal data are not going away. If anything, they're becoming more determined and more resolute. We need to do what we can to protect California consumers and make sure that their information that's so important personally is protected. Unfortunately, we know data breaches are part of the present and will be part of the future. Not only is it important to prevent them from occurring, but it's also important that if they do occur, the correct steps are taken to protect consumers. Although we know that consumers are made financially whole under existing circumstances if payment information is stolen, the damaging effects related to identity theft can go on for years. California leads the nation on privacy regulation, and that is what AB 1710 will allow us to continue to do, be the leader in our country. Not only is this important for consumers, but retailers as well. Consumers do not want to shop at a store that has had issues with data breaches. Preventing them in the first place helps us all. Now, Assemblymember Wykowski and I want to ensure the safety and soundness of our constituents, our businesses, and our state. AB 1710 will protect California consumers and make sure they are notified in a timely manner, as well as inform consumers where the breach occurred. Financial institutions should not be taking the heat when a data breach occurs at a retailer, but under current law, it is the financial institutions that are required to notify consumers if a data breach occurs, rather than the business itself. I think we all share one common goal today. Everyone in this room is a consumer. And when we act as a consumer, we should not have to doubt whether our personal information is protected.